Good evening, this is John Milburn, Laws 11057 Introduction to Law. It's week number 9. Tonight I commence with some commentary in relation to ethical behaviour, and I refer to your textbook, pages 435 through to 455. You can read that for interest and context. But when it comes to ethics, you'll find valuable information on the Queensland Law Society website. For example, a quote that I extracted resonates with me. This is from McLaughlin and Dungowan Manly Pty Ltd. It's a 2011 New South Wales decision, 717. And at page 30, the court said, "It needs to be emphasised that the efficient conduct of commercial litigation, indeed all litigation, can only be assisted by restraint, moderation, sensible cooperation and sound judgment. Indeed, the due administration of justice demands it. This is part of the wider duty to the court." So your duty when advocating on behalf of a client in a commercial context or an adversarial context is to do so with restraint, moderation, sensible cooperation and sound judgment. It is not a case of doing anything it takes, as it were, to win the case. Far from it. You must do so within the context of your wider ethical duties. So please keep ethics in mind throughout everything that you do, every question that you answer, every advice that you provide, the way you conduct yourself on a day-to-day basis. Ethics is very important. Speaking of which, a tip, retired Major General John Cantwell said that with respect to leadership, good leaders take time for reflection. When concerned by an ethical dilemma or problem, they take time to reflect and think ahead, and that's important. So as you come across issues that that require some thought, think about your ethical duties and think about and reflect upon what you're doing. Now, what I really like about that quote is something that I have emphasised consistently, I think, throughout the course, and that is that you must think ahead. Thinking ahead is critically important and it solves a whole range of issues. Okay, so having said that, if you have any issues, please unmute your microphone, join us live, or use the chat facility. In the meantime, what I propose to do is share my screen and have a look at the document prepared by Judge Dean Morzone QC to do with ethical behaviour in and around the courtroom. So if you've got Moodle open, you can access that document. It's excellent. 50 basic tips on how to behave in and for the courtroom. You should see that on your screen. Is that right? Just give me the thumbs up if you can see Judge Morzone's document. Thank you. All right, so this document was prepared prior to His Honour's appointment to the District Court. Judge Morzone is, or was before being appointed, an advocate and also a mediator. It's very common now to have the two, and you might be aware I'm a nationally accredited mediator. Okay, so read this document, but when you do, please do so actively. Now, by that I mean, don't just passively read the material and let it float over your head. Don't read it in isolation. But think about the content in terms of the study that you've done so far and think about it in the context of an exam. And the sort of exam question that you might expect to be faced with is you're a first-year lawyer, you're confronted with this particular scenario. It may involve courtroom, it may not. What do you do in that circumstance? But importantly, what do you do in advance to plan for that type of circumstance? So read this document actively. For example, point 2, be punctual and arrive on time. It's very easy to gloss over that and say, yes, that's fine, yeah, got it, be punctual, be on time, be well dressed, got it, without really thinking about it. I want you to think about how you will ensure that you're punctual and arrive on time. There are many ways to do it. And think about some things like having your appearance slip prepared or noted. And you might say, well, I don't know what an appearance slip is. Good. Well, we need to find those things out. An appearance slip is really just a slip of paper which in the superior courts is prepared by the advocate, typically handed to the bailiff or perhaps the judge's associate prior to the court commencing, so that when his or her honour comes into court, they will know essentially who you are. You still announce your appearance, and I think we talked about that last week, the process of announcing your appearance. But so part of being punctual and arriving on time is knowing that you need to be there before you start so that you can do things like prepare the appearance slip. So read through the document and absorb that, do it in an active manner, and if there are any questions, please raise them on UCRU. I think there'd be some really good questions that come of this if you're reading it in an active manner. So bow respectfully. When you go into a court, typically the first thing you must do is take a step into the courtroom, stand still for a moment, bow. Don't go too far. It's not, you don't get to the horizontal or anything. It's, but it's not just a quick cursory nod of the head either. So it's stop, prop, and bow, I suppose, from the waist, but not too far. And then move on. Then take your seat. Okay, so it's respectful nod of your head and shoulders. Okay, so not the bow, not from the waist, just the head and shoulders is fine. So while you're waiting, just be really careful. It's so easy to fall into the trap of fiddling with papers, looking around. I mean, obviously there are circumstances where you need to do that. You need to be prepared. And sometimes you need to do that while you're in the courtroom. Just be very careful, and I've picked this up from the times that I spend on the bench. You can really hear and see so much from the bench. So keep that in mind. Addressing the court, I think we talked about that last week, the process of addressing the court. Get off to a good start. First impression is important. So when you're planning for some advocacy, think about how you're going to open. Think about the IRAC method. Are you going to use that? Are you going to implement that type of reasoning when you're talking to the judge or the magistrate or the tribunal member? Maybe you start with a conclusion so that the court knows where what you intend to do ultimately and work backwards from there. So when I say active reading, it's all very well, get off to a good start, but think about how you will get off to a good start. Think about checklists, form, precedents. Think about ways that you improve your performance. Can I just say as a very practical tip, which no longer applies, but when years ago we would address a magistrate as Your Honour, sorry, as Your Worship, and the courts, in the superior courts, we would address as Your Honour. That changed 10 years ago. Now we say magistrates and judges, they're all Your Honour. But to be honest, when you're appearing day in, day out in the magistrate's court and it just rolls off your tongue, Your Worship, Your Worship, Your Worship, what I used to do when I had a matter in the superior court, I'd actually have a yellow sticker and it said Your Honour. And so the very first thing that I would do as I made my way to the bar table, I'd have that sticker there so that I would then remember to say Your Honour. Now, of course, the same thing happened when the magistrates became addressed as Your Honour instead of Your Worship. I just used that same yellow sticker in the magistrate's court just to remind me to say Your Honour. Okay, so practical things, thinking ahead, they're sensible ways of doing it. You want to get off to a good start. Be uncompromisingly ethical in every aspect. Your behaviour to the court must be exemplary. This is all really good advice from His Honour. And if you haven't already looked at his video, which is on YouTube, on Moodle, please do so. It's excellent. And I know I'm skimming through very quickly now. Look, don't speak too rapidly. It's a really important point. Most first up advocates that I see speak too quickly. It's probably nerves. It might be a little embarrassment. You don't want to labour over what you say, but you want to ensure that your diction is appropriate and the court can hear everything that you are saying. That means slowing down just a little. Practice it. And maybe have a yellow sticker. Slow down if that's the concern that you think you might have. And there it is. His Honour said, annotate your notes to prompt you, slow down or speak up. No need for theatrics. Now, really importantly, when you're talking to a court, nobody wants to know what you think and nobody wants to know what your view is. You can make a submission. You can say, I submit, or in my submission, but you don't say, I think, or this is the appropriate thing. I mean, there are a lot of little tips when it comes to court proceedings, and I'll move away from that document. I'll stop the share now. A lot of little tips when it comes to advocacy. Just think in terms of some of the court niceties, which you'll probably only pick up with a bit of experience and a bit of hanging around the courts. For example, if it comes to 1 o'clock and you're aware that generally courts go into recess for lunch at 1 o'clock. In the magistrate's court, it's much more flexible, but in the district court, with the jury particularly, 1 o'clock, the court will want to retire and usually resume at 2:15, maybe 2:30. If you are on your feet addressing the court at the time, you notice it's 1 o'clock, I mean, you've got to be careful not to be too direct. You don't say something like, is that lunchtime now, Judge? Or, what time do you have lunch? None of that. It's much more subtle. We don't say Judge in court, we say Your Honour. So it might be, Your Honour, I note the time. Or, Your Honour, is this a convenient time? I mean, it's code talk, but you and the judge know what it means. Or it might be, Your Honour, I am nearly finished with this witness, perhaps 5 minutes. Would Your Honour like me to continue? Something along those lines. Okay, so have a look at Judge Morzone's material. It's excellent. And if there are any questions from that, please let me know. Okay, so courtroom ethics, the layout of the court. There's a lot of material on the internet now about how a court is laid out, but essentially we talk about the bar table. In Queensland, typically in the magistrate's court and the superior courts in criminal jurisdiction, prosecutor to the right, defence to the left. As defence lawyer, I would expect to have my client to my left, that is away from the prosecutor, and take it in turns. Do try to avoid a situation where both parties are on their feet at the same time. That's really frowned upon. You don't want to have that situation. So one person on their feet addressing the court, when the other person starts to say something, sit down. I mean, it may be you're not finished, but the court will appreciate that. And if the court didn't appreciate the interruption, the court will let that person know and invite you to stand up again. So just be aware of that. In the children's court jurisdiction, typically magistrates in that jurisdiction will invite parties to sit and remain seated throughout the proceedings, with one exception. The young person who is the subject of the charge is required to stand when addressing the court in those circumstances. All right, so in the material, I think I've made reference to this publication. That's an excellent publication from the Queensland Law Society. It costs a little bit of money, but it's well worth the expense. It's annotated, so it's got some good cases as well. And it provides there are some guidance statements in relation to ethical obligations. You can have a look at that through this document or on the website for the Queensland Law Society. For example, there's a very good guidance statement in relation to the question of undertakings. And I think I have a commentary on that as well on YouTube. Hopefully it's on Moodle. Pay some attention to that. Really understand what the role of an undertaking is, what it means for a solicitor to give an undertaking, what it means for a solicitor to fail to comply or fulfil an undertaking, and think about the circumstances where it might be too easy to inadvertently place yourself in a situation where you breach your ethical obligations by giving an undertaking that could never necessarily be fulfilled by you. So if you're going to give an undertaking, make sure that you can personally, ensure compliance of that undertaking. If you're reliant upon another person, then couch your undertaking in conditional terms, meaning subject to this occurring, I undertake to do this. Or if you're undertaking on behalf of someone else, typically a client, then ensure you use those words. On behalf of my client, I undertake to pay the rates, or whatever it might be. But if you say the words, I undertake to do this, then guess what? You are liable. And if you say something to the effect that I undertake to pay $500,000 to this beneficiary next week, then it doesn't matter that the cheque didn't clear or your client failed to provide the $500,000, you are responsible for that. Okay, so think about undertakings. That might be an exam tip. Professional ethics. So you have duties to the court, to the client, to your family, to your colleagues, to your employer. Think about how you juggle those things and how you might treat all of those different stakeholders. I don't like that term, but it's appropriate, I guess. Think about how you might engage with those stakeholders and treat them all fairly and ethically and appropriately. For solicitors, the Australian Solicitors Conduct Rules, very important. If I could just outline some of the more important ones and treat this as an exam tip, I guess. The fundamental duties are in Rules 3, 4, 5 and 6. That's the guiding. There's a question, is an undertaking a legal promise beyond the normal scope of expectation? Not necessarily. If an undertaking is an undertaking, and if you give that undertaking, then it would be a rare circumstance, if at all, that the circumstances that led to the provision of the undertaking will come into consideration. In other words, it's almost like an absolute liability, a strict liability. You give the undertaking, it's got to be complied with. Whether it's within the normal scope of your authority, whether it's something that had someone relied on information from others or whatever. You've just got to be really careful when it comes to undertaking. I hope that answers the question. And thank you for that question. Feel free to unmute your microphone and come in and ask a question or use the chat facility. So I mentioned that the fundamental rules are in 3, 4, 5 and 6. You should have a good understanding of those fundamental rules and maybe have a look at some case law relevant to those rules as well. The issue of relations with clients is dealt with in Rules 7 through to 16, and that includes an obligation at Rule 8.1 to follow the client's lawful, proper and competent instructions. So think about those words as well. So your obligation is to follow your client's lawful instructions, but bear in mind that the paramount duty is to the administration of justice as well. The client's proper instructions. Think about your ethical obligation generally. Is it a proper instruction to do this, or is it improper? And I guess the test is, if you do something, if you follow through with some instruction, ask yourself, how would I feel if I'm standing now before the Legal Services Commission and I'm required to justify what I've done or what I've said? Do I feel comfortable with it? If you feel uncomfortable, it's probably a good sign that you should ask for some help, seek some guidance, or undertake some research. You've got to be careful. You've still got to do your job, but there comes a point where you must say, I don't think so. And also think about your client's competent instructions. I think we've talked about capacity issue before. So in my role as a member of QCAT, I often hear matters involving administration and guardianship for adults. That requires consideration of the definition of capacity as it appears in the Guardianship and Administration Act 2000. This is Queensland. Worth having a look at that definition of capacity, because in the context of your obligation to follow your client's competent instructions, probably we'd look at the definition of capacity in terms of that. So your client has to be competent to provide the instruction. That's not necessarily, I'm not saying that is equated to the definition of capacity, but that's one of the guidelines that would determine whether or not the client was able to give competent instructions. All right, so advocacy and litigation, rules 17 to 29 inclusive, that deals with your responsibility as a lawyer, solicitor in this context, to the court, the process, to your opponents, to witnesses, and special rules about cross-examination and prosecutorial duties. Prosecutors have a special role to play. Prosecutors generally model litigants. That means is that they have a positive obligation to ensure that the case is presented in a fair and balanced manner, and not necessarily for the ulterior motive of achieving, say, a conviction, but to ensure that all relevant and appropriate and proper evidence is presented to a court. That's what we mean by a model litigant. Have a look at Rule 21.2, and that is that solicitors must take care to ensure that decisions by the solicitor to make allegations or suggestions under privilege are reasonably justified. Now, that's probably all I'll mention about that book, but it is excellent. It's really good reading, and you can almost live by that in terms of your obligation as a solicitor. Now, for barristers, very similarly, in Queensland, the Barristers' Rules 2011, have a look at the Bar Association of Queensland website, and in particular, have a look at advocacy rules. That's rules 12 to 14, the rules about duty to the court, 25 to 36, to the client, 37 to 40, and court process and privilege, rules 59 to 67. Okay, if there are any questions, if I'm moving too fast, please let me know. In the exam, you may be asked a question about conflict between professional and personal ethics. Sometimes there's a difference. The traditional view is that a lawyer must act in the best interest of the client, even if that is inconsistent with the lawyer's own personal values. So it might be that your task is to represent a person who believes they should have received more from the estate of a relative, let's say. When you go through the material, you may say, I don't think this person should have received anything. However, your task is to advance the best interest of the client in those circumstances, even though it may be something that you would not do personally. Look, the alternate view is that one of responsible lawyering that emphasises your role as an officer of the court and trustee of the legal system. I'm not sure that necessarily comes to a different result, but have a look in the text about the difference between the traditional approach and the responsible lawyering approach. And Parker and Evans, you'll see in the commentary, favour an ethic of care over other approaches, adopting a more holistic approach. So there's a few different ways that one can consider the difference between your own personal values and your professional values. Okay, hopefully there are no other questions. Or no, I'm sorry, I mean to say, hopefully there are questions. I like questions. So please feel free to come in if you wish. Next week we're going to broaden your horizons a bit, do some brainstorming. It's an opportunity to think laterally about providing holistic advice. People don't like it when I say holistic advice, lawyers. We're not, they think in terms of holistic medicine. It's not like that. What I'm really talking about when I say holistic advice is think about what it is that you seek to achieve on behalf of your client, what's in the best interest of your client. That is not necessarily pursuing the legal avenue that you think is the most appropriate, if I understand. For example, your client may have a very good case, but your client may be terminally ill, and it may not necessarily be in the client's best interest for you to actively promote litigation that you know will outlive the client. That's just a pretty extreme example, but what I'm really getting at is there's a whole range of different avenues that a lawyer should and is able to consider. Alternative dispute resolution comes to mind, a whole range of different options that are available there. Litigation, of course, negotiation, and so on. So we'll ask you to think about some of the advantages and disadvantages of different options. We'll try to generate some of those options. We'll think about the risks and the rewards, talk about costs, timing, alternatives that might be available, and of course all of that in the context of your obligations as an ethical and knowledgeable provider of services. Okay, so that'll be for next week. Now, by this stage, you should all have received your feedback in relation to the second assessment piece. If I could just have I'll just put it on speaker view. Did we all receive our assessments? We got those? Okay. Generally speaking, were we happy with the audio feedback again? That's okay? All right, I'm getting a few thumbs up there. Thank you. Well, I'll persist with that. In terms of the feedback, generally the work is really good. I'm very happy with the way people are presenting their work. You know, Central Queensland University needs to find its place in the world for law students. The way I see it is that people will regard graduates of this university as being highly competent, highly professional, highly ethical, and people that really do present in every way very well. So inspire confidence. And that's why I'm so keen to ensure, you know, in this introduction to law course, that your documents inspire confidence of the reader, that at first glance, the reader says, okay, this person knows what they're doing. There's no obvious mistakes. And to a trained eye, things that just aren't quite right stand out really quickly. So have a look at my sample document. I won't go through, I'll labour through that. I think we've talked about that enough. But make sure you follow all the basics. When you're typing legislation or case law, make sure it's in italics. Be innovative, use flowcharts, etc. Make sure your footnoting's right. Most of you have got this down really well now. We're even using pinpoint referencing well. So please keep that up. I'm very encouraged and I thank you for following those basic guidelines, but please keep it going. Legal research, I think we've talked about this a fair bit, but the IRAC method, the MIRAT method, which is in a practical guide to legal research, the CIRAC method. Are there any questions about how we use those methods in the context of legal research? So by what that I mean is, if you're researching a problem, I guess one of the things you need to do is identify the legal issue. That may not necessarily be an easy thing because in a contract dispute situation, it may be a situation like consumer law, or it might be even criminal law issues as well. Just had a random question. What other subjects do I teach? Yeah, I teach environmental law, which is a real favourite of mine, and alternative dispute resolution, which I also love. So they're the ones that I do. I think next year, or this year, later this year in term 3, I'm doing statutory interpretation as well. So there is the issue of various subjects in ways of undertaking research, but I think identify the legal issue, identify the material facts, and when it comes to researching, sometimes you can key in keywords and that will draw out material for you. When you have found some appropriate research, think about how you apply those rules to the facts of your particular case. And we go back to the old reasoning example. So reasoning by analogy, what is similar, which is a precedent. Inductive reasoning, where you're looking at a specific principle and forming a general conclusion. So that inductive reasoning process, that's relevant to your legal research as well. Deductive reasoning is where you're narrowing, you're taking a general principle and you're bringing it back towards a specific conclusion. So what I'm really trying to do in brief, and I know I'm moving very quickly, is suggest to you that when you're doing your legal research, have a system in mind. Think about how you will go about doing the research. And my suggestion is think about IRAC, because that's going to be relevant in terms of the way that logically we think about legal research, and think about those legal reasoning rules that we talked about in your text as well. Okay. In terms of the online law, I'm looking forward to your third assessment piece. You can talk about Ostley, you can talk about J. Barnett, LexisNexis, Westlaw, anything that you like. If you think it's interesting and it's worth saying, then tell me. And when it comes to the third assessment piece, you can be pretty broad if you wish. You can say, look, this is a general introduction and here's a snapshot of lots of different ones without great detail. Or you may say, look, I'm aware of a number of them, all of these, but I've selected this one because I think there's a feature here that is worth describing, and here I go, and I'm go into much more depth just on that first point. Or you can say, look, I've come up with a legal scenario and here's how I went about undertaking some research, or suggest you do research to deal with this particular problem. So, question is, in the third assessment, to what end did the research go? That is, bill to legislation, case law to local laws. Yeah, you can talk about the way in which laws work their way through the process, become case laws, etc. I think it's more a case of just selecting a methodology that you think is appropriate. And I guess, in a way, if you go with the easy description, it's a bit like, I don't know, how can I describe this? Olympic diving. Someone executes a perfect dive, but it's a really simple routine. They'll do okay, you'll get a good pass mark. But if someone goes for a very difficult dive and pulls it off, they'll get a better mark. I hope that makes sense. So if you choose to go on a really basic sort of level, there's nothing at all wrong with that, but you may not achieve an ultra great mark. You might achieve a very good mark, but not necessarily, you know, a 95 type mark. But if you go for something that's a bit tricky, something new, something that I say, wow, that's impressive, then you can probably expect to get a better mark. If you get it right, you've got to get it right though. Okay, so if there are any questions about that third assessment piece, let us know. There's one here. Are you happy for us to show our legal research with just one database, or would you prefer we go to multiple databases? That's entirely a question for you to determine. Whatever you think is the right way. If you go with multiple databases, you won't be able to focus in as much detail. So it'll be a more general spread, but you can still get a very good mark if you do that. Likewise, if you choose to go drill down into one database only, that's fine, but I'd expect to see something more than just a general comment about it. So this third assessment piece is really broad. There's really broad parameters, but bear in mind also that I'm keen to see how good you are at communication. So that's part of the examination as well. Your ability to persuade, to educate, to use your voice, to use all the communication techniques that we've talked about are all relevant to this assessment piece as well. Okay, so please continue to ask questions about that as I move through anything else. So, holistic advice, I'll just give some broad guidelines to this. This is what we'll be doing next week in the brainstorming exercise. So you need to think about different litigation options. In a sense, when someone comes to you with a problem, it's almost like a little bit of legal triage, yeah? So you're thinking, okay, there are a range of different options here I think might be relevant, and what you then try to do is tailor the advice to the needs of that client. You need to think about, is the client acting on emotional logic? That might be relevant. So a client may come to you and say, I've been defamed. I don't care what it costs. I'm selling my house. I just want to get this person, and I don't care about any of the consequences. Just get them. You just think, well, hang on. Let's provide an advice. Let's have a meeting down the track. So you've got to think about the emotional state that your client is in as well. And you may need to cater for the circumstances of the client, intellectual, socioeconomic, age, cultural, risk perspective might be important. Employment, are they employed? Are they unemployed? So that's an issue as well. That leads into capacity issues. We've talked about that before. So if you get a borderline intellectually disabled person who has received a very substantial payment and says they want to pursue really unrealistic or unremunerative litigation, like maybe a defamation case, what do you do? So what I'm really suggesting is that in that brainstorming exercise, you're thinking in a much more broad manner, and it's not just a case of a client comes to you and says, I want to sue for defamation, and you say almost blindly, yes, I'll take those instructions and I'll issue the proceedings tomorrow. You've got to think in more holistic terms. So that's what we're really talking about. That's what I want you to start thinking about for next week. So you need to identify the difference between what is ideal and what's realistic in many ways, bearing in mind your ultimate role is to ensure the administration of justice. Now, as a legal advisor, there might be some legal, but also some non-legal options available for a client. Maybe the client needs to hear something like, I think we need to get some counselling involved. I mean, I do that regularly when speaking to criminal law clients who are facing very serious charges. So we want to ensure that they're thinking well and they can cope with what might be a long and very stressful ordeal for confronting them. So think about whether you need to provide specific legal advice or general advice. Think about then some specific issues to do with the problem. Think about some of the broader issues. Where did this dispute arise? Is it an interstate dispute? Is it a federal dispute or a state dispute? Who's the dispute against? Don't go off and race just because the client says, please sue John Smith. Bear in mind that it might be actually John Smith's company that is involved in the dispute. So you need to take what the client says and then take it a step further by thinking more broadly, because you may go down the wrong track if you simply act on the bland instructions from the client. So think about when the dispute arose, because there might be statute of limitation problems, and think about some other self-help remedies that might be available. Sometimes maybe, is it appropriate in giving holistic advice to recommend to a client that perhaps they should try to talk this issue through with their neighbour? Maybe have a cup of tea, share a beer, I don't know. Is that what lawyers should do? So part of your role in thinking about this is to think about what the lawyer should do and what the lawyer might be able to do in terms of providing this holistic advice that I'm talking about. So are there specialist legal services that might be available, or even non-specialist, specialist non-legal services that are available? Think about ADR, should that become involved? And think about your ethical behaviour as well. A client says to you, I'm ready to pay substantial funds for this task, but you may think, well, this client could actually be eligible for legal aid. So are you entitled to say, well, I'm not even going to think about legal aid, I'm just going to take the client's money and act in these circumstances? So these are things that I want you to think about. Okay, and then think about the monetary limits for the different courts and tribunals. I think we talked about that briefly last week or previously. Queensland Supreme Court, unlimited monetary jurisdiction. Think about the levels for the District Court, the Magistrates Court, and the QCAT. QCAT's odd because you've got the Small Claims Tribunal, which is now the Minor Civil Disputes jurisdiction. That has a monetary limit, but the rest doesn't. It's unlimited for the general damages area in QCAT. Okay, so I know I've talked a lot. I hope that I haven't gone too quickly, but in the context of the dispute brainstorming, what I want to do next week is maybe talk about someone who's come to you and says that they have a dispute, an issue to do with, say, debt recovery or a consumer dispute. What options are we going to generate for consideration with that client? So that's what we'll be talking about to some degree next week. All right. Are there any questions then in relation to anything that we've been talking about? So one question that's come through is, for the third assessment, can we show how we find a particular case and then research the relevant legislation pertaining to the case and find which section of the Act the defendant was convicted under? That'd be great. You know, that's a really good example. So we're just sort of taking it in reverse. So yeah, the whole idea of this exercise is to have some flexibility, and if you think this is a really good way of explaining some particular type of research, then feel free. You know, again, in the context of what we talked about earlier tonight, don't rush it. Don't race through it simply because you want to get more information within that period of time. What was the commentary that we read? Something about don't rush the commentary. Make sure that you speak appropriately and correctly. So that would be a great exercise to do. Thank you for that. Is there a minimum time? No, I think there's no minimum time. I can't recall the maximum time. I think I did prescribe a maximum time. I'll just put you on gallery view, 12 minutes. So thank you for that. All right. Well, thank you very much all for joining me tonight. Unless there are any other questions, if you want to unmute your microphone or ask a question through the chat facility, we might call it quits at that. So thank you very much for joining us.